The socioeconomic consequences of the pandemic and conflict have paused progress and worsened outcomes for women and girls. Coordinated and comprehensive action will be needed to create sustained improvements and halt the risk of further reversals. But how do we achieve such action without addressing the underlying patriarchal structures that lead to women's underrepresentation in power? Good morning, everyone. My name is Matthew Shahi, and in this session, our distinguished panelists will explore the question of women in power while paying particular attention to the gendered nature of constitutions and their effect on women's citizenship, the effect of gender quotas in Brazil's political system, and women's incorporation in Latin America's high courts. The session also marks the publication of Ruth Rubio Marin's new book, Global Gender Constitutionalism and Women's Citizenship, a struggle for transformative inclusion. Dr. Rubio Marin is professor of constitutional law at the University of Sevilla and holds a UNESCO chair in human rights and interculturalism at the Universidad Internacional de Andalucía. She is also adjunct professor at the School of Transnational Governance at the European University Institute, where she leads the work on gender, diversity, and governance, and is a member of the Hausa Global Law School program at New York University. Professor Rubio Marin's research focuses on comparative constitutionalism, law and gender, immigration and citizenship, and transnational justice. Rubio Marin studies how public law creates categories of inclusion and exclusion around different axes, including gender, citizenship, nationality, and ethnicity. Following Dr. Rubio Marin's presentation, she will be joined in conversation by Dr. Andrea Castagnola, who is adjunct professor at the Department of Political Science and International Relations and the Law School at the University Torcuato de Tella, and is an affiliated researcher at Law Transform. They will also be joined by Dr. Catarina Barbieri, who is a researcher at the Gender and Law Center at FGV Sao Paulo Law School and is currently editor-in-chief of Direito GV Law Review. To begin, Dr. Rubio Marin will present her new book, Global Gender Constitutionalism and Women's Citizenship, a struggle for transformative inclusion, which is coming out from the Cambridge University Press, and offers a comprehensive feminist account of constitutional law and asks, to what extent constitutions affirm women's equal citizenship status? Without further ado, please join me in welcoming Dr. Rubio Marin to the stage.
Time. Good morning, everyone. It is an absolute pleasure to be here with you, and thank you to the Bergen Exchanges, and God bless you all. Siri, Helen, I mean, this is an amazing thing. I came here for the annual cup. I collect the cups. This is the reason I'm here, mostly. So I hope to perform adequately to get my cup. So it's really thrilling to be here to present my book, which is coming out, I think, in a couple of weeks. And I wanted to basically share with you what the book is about and also why I decided to write this book. Sometimes we, don't say why, what the motive is. I mean, the main question is the question that was already mentioned. To what extent and in what ways has constitutionalism facilitated or impeded women's citizenship around the world and since its inception? Now, this is a crazy project, as you can imagine, but I kind of thought, sometimes you actually should dare to think big. And you're going to be killed, you're going to be criticized, it's not going to be inclusive enough, it's not going to be anything enough. But I felt that since in 2005, Beth Baines and I produced The Gender of Constitutional Jurisprudence, which was an edited volume, trying to lay out, I think for the first time, what could be the agenda for comparative constitutionalism through gendered lenses. There had been really a thriving area of scholarship on this domain. But I felt that the scholarship that had been produced was actually either focused on specific themes or focus on specific country case studies, but I felt the time was ripe to try to bring it all together in some kind of meta-narrative, meta-story, meta-her story, as opposed to his story. And that's what I tried to do. I also felt there was an overrepresentation of the Anglo world, largely speaking, with some exotic European additions in the field. And so I felt that to the extent that there were being generalizations on comparative constitutionalism and gender, they were a bit biased. So I was a bit uncomfortable about the epistemic hierarchies entailed in the domain. And I also wanted to do this for you, for the younger generation. In the introduction, which is a very personal introduction, very atypical of constitutional law books, I mentioned a couple of anecdotes of how I was challenged when I started my career and I decided to focus on gender in the constitutional law domain. No, this was not an obsession around proportionality, originalism, judicial review, or the same old same. It was an attempt to do something different, but I was really challenged. So my hope was that by producing this book, but also by leading and being part of 3 regional projects that have accompanied the production of this book, one focusing on Central and Eastern Europe, one in Latin America, and one in Asia, we could collectively produce sufficient body of scholarship so that, the younger generations wouldn't, with a passion for feminist or queer constitutionalism, wouldn't feel that they're working on the margins of the discipline, and that it should more and more fall on those who don't read this scholarship to justify why they don't, and yet they call themselves constitutional scholars. So that was a goal. And then finally, this attempt to produce his story of constitutionalism. So we could hear the first opening lecture confessed it. Yes, the gender order was foundational to liberal constitutionalism. I think there's wide acknowledgement of that now, but yet I felt that in spite of this wide recognition, there was a lack of a comprehensive analysis of what this fact, this original sin, this establishment of a gender order since inception of liberal constitutionalism had actually meant in terms of the potential of constitutionalism for the emancipation of women, but also sexual and gender minorities on the one hand, but also, what had this done to the field itself? How had it shaped doctrines? How had it shaped conception of rights? How had it shaped the discipline? When we decide what are the landmark cases, the doctrines, the irrelevant constitutional moments, are we taking her story into account when shaping all of this? So, in essence, I want you to think of this project as one around the notion of gender order disestablishment. So if you think of religious establishment and disestablishment, this is a trip about how this gender order was established, definitional of liberal gender constitutionalism, and what have been some of the ways in which that original gender order has been challenged across the world and throughout time. And so what I end up doing, and this is the structure of the book, is that I end up defining certain forms/faces. I say forms of faces because they don't present themselves in every jurisdiction. They don't present themselves in a timely manner. But when I say faces, what I do is identify when in history they first came out, even though, again, they don't represent a linear account of every country's evolution. But so I identify these forms of phases of gender constitutionalism, started, of course, from exclusionary gender constitutionalism to then what we could call egalitarian constitutionalism. And within this egalitarian constitutionalism, I differentiate between inclusive, participatory, and transformative gender constitutionalism. Now, this is the structure, and I realize you can't read it all. Part of what is challenging is that it is, 380 pages, but just 5 chapters, because I wanted the structure to be very clean and simple. But you can get a sense of what the book covers starting from the constitutional establishment of the gender order. So I start from the revolutionary moment. I look at 19th century constitutionalism, first wave demands, and how they could or could not, for the most part, rely on constitutions to push forward their agendas, the right to suffrage, the right to work, the right to sit on a jury. And what I try to do, not only in this chapter, but as much as possible, and of course in an anecdotal way, because otherwise I would have never finished this, and it took me quite a long time to write it already. But what I try to do is to not only explain what permeated into the constitutional text or case law, but also the claims, the struggles of women that never made it to the text or to a winning case. And yet, I thought that if this was a project about looking at how women conceive themselves vis-a-vis constitutionalism, this exercise of constitutional claims and civil society mobilization had to be part of her story of constitutionalism. So I then go into this inclusive constitutionalism, which is, I think, what we most tend to think of in terms of when kind of women make it as equal citizens within the constitutional sphere. And in that inclusive constitutionalism, I actually lay out two very different models, the American model and the European models, which are slightly different in part because of the fact that since in the interwar constitutionalism, the first sex equality provisions made it. I'm thinking of the Weimar Constitution in Germany. They made it to the constitutional text, but so did family protection and motherhood protection provisions at the same time as sex equality provisions. So that kind of led to a maternalist, accommodationist theory of constitutionalism. And vis-a-vis the American, which stayed more as in the anti-stereotype reading of constitutionalism with a focus on formal neutrality, etc. So I describe this inclusive constitutionalism. So I say no, post-World War II is not the highlight moment for women, although we tend to think that it is, because in a way that was the heyday of the breadwinner family model, culturally speaking. So it's only in the 70s, and much more in reaction to the second wave, that we see these women really coming to the center stage of constitutionalism. However, I criticize the shortcomings of both these variants of constitutionalism, and because of the limited domains in which sex equality applies, because of the dominant formalistic approach to equality, but also because in the end, it's an assimilationist constitutionalism that really looks at man as a standard and tries to give women the same rights. I go on to what I call participatory constitutionalism, and here I'm more moving historically in the 90s, and I think this is a really key milestone, which is often underscored, not sufficiently underscored, because it doesn't have much relevance in the US. So this is an example of the epistemic hierarchies and what it does. Because in this moment, there's a shift in gender equality, which goes from equal rights to equal representation. Women want to be decision makers. This is the Beijing Platform for Action. This is the transnational women's movement, which then, of course, sets new human rights standards, which then permeates into this new forms of more participatory, inclusive, social movement-led constitutionalism. So in this phase, you see women becoming much more active constitution makers, whether it be through civil society, in constitutional assemblies, as litigators, as judges. So they make constitutions, but also they broaden the agenda of constitutionalism. And this then takes us to the last form of constitutionalism, which is what I call transformative constitutionalism, which is the missing piece. If the original sin was the, patriarchal, heteronormative, cisgender family order, they cannot be a true disestablishment of that gender order unless you challenge the family dynamics, the family domain, the definition of the family, the exploitation and extraction of care work. And so in this last phase or form of constitutionalism, I describe both innovations in terms of constitutional provisions, but also doctrine, which finally take on board the agenda of looking at care, reproduction, equity, new fatherhood, I basically think that there's more promise in the European tradition because at least it talked about care. Now, it assigned it to women, but at least it talked about care as a citizenship dimension. So it's a question of neutralizing or de-gendering care, but at least you can centralize care. And in fact, you have some very exciting provisions in these new constitutions that center care. Now, of course, as you could imagine, the disestablishment of a gender order, and though I mostly look at it from a women's citizenship perspective, comes hand in hand with this disestablishment of heteronormative marriage. And so the book discusses same-sex marriage. It also discusses the new or in-the-making right to gender identity as a form or manifestation of the dissolution of this original gender order. Now, the monarchy did not die in one day, right? The idea of religious establishment has not died yet, and even where it has, to some extent, it didn't happen in one day. And of course, why would we expect the patriarchal gender order if it was this definitional, this essential, this foundational, to die in one day? We couldn't. So the last part of the last chapter describes the gender backlash. It describes the forms in which constitutionalism is being co-opted by those who oppose precisely all this venture that I have just described. And, not surprisingly, the fact that this was the original gender order also facilitates the use of constitutional language in order to combat or to resist, right, these inroads and this emancipatory process. So this is what I wanted to share with you, and I want to leave time for my peers in the panel and for the questions, hoping that you will like the book and that especially the younger generations to whom the book is dedicated will be inspired by it. Thank you.
Thank you so much, Dr. Rubio Marin. And so I'd like to welcome Catarina and Andrea into the discussion and give their reactions to the book and what they found in it, and pay particular attention to your own context and how they could relate.
Okay. Should I go first?
Yeah. So Andrea.
Okay. Okay, so thank you very much for the invitation. I'm very happy to be here in Bergen. It's always nice to meet friends and colleagues. I really enjoy your book. I must make a disclaimer. I just only read the introduction and skimmed part of the book. So my reactions are going to be based on that and your presentation. So by reading the introduction, I realized that it was going to be very disruptive and a de-learning process of how I was used to learn on this topic, right? So it was very, at that beginning point, very interesting for me to read a different perspective of a topic that I have read so far in the past years. So I really like the different waves. At some point, you talk about typologies in the introduction, and that was a comment that I was about to make you, because I don't think that typologies is the best term to use it, because typologies have to be exclusive, and I think it more works like waves or phases as you present it, but not that much as typologies. And I think that the argument, as you presented in the introductions, can work very nicely with McCann books, Right as Work, right? And at that point, I was wondering at what point this story of waves can also travel to other minority groups that want to advance in their claims and right through courts. And I think that these phases, for some groups, as we have learned in some minority groups in other countries, can help them to organize and to think the advancements and back and forward in their fights towards their rights and claims. So I have a question that maybe can be, I don't know, provocative, but why do you talk about gender and not women directly? Because
why do I talk about gender and not women? Okay.
Yeah, because when I read gender, I thought it was going to be broader than male women thing, but at the end, when you start reading the book, it's obviously about women. So this was like a general question that a reader can have at the beginning of the book. And I think that especially to NGOs and grass movement organization, it's not the same to talk about gender than women. I'm thinking about feminists here. And what I was wondering, and I'm really looking forward to read the book, is what about the role of women judges on this different waves? Because when I was reading the cases that you select about Argentina, the first Argentine justice in the Supreme Court is from 1970s, and then that it was for a couple of years, and then it was not until the early 2000s that we have women in the courts. So the cases that you select for Argentina, some of them, there was no women in the Supreme Court, so I was wondering, what was the role of judges in those cases? And then when there were women in the court, how that changed? Because I was wondering whether these waves were always bottom up, or at some point there was a top-down, communication between the justices, especially women justices, and these cases that arrived to the court. So I think I'm going to leave it there.
Thank you.
Thank you, Matthew, for the introduction, and congratulations on the release of the book, which will happen very soon, and I think we're all very excited to read it. I had the chance to read an article that I would like to mention on constitutionalism and women's citizenship from 2021, that, as I was checking with Ruth this morning, summarizes some of the arguments in the book, so I think it might be helpful for those who are interested in what you just presented, and obviously your presentation clarified a few points. I come from a different perspective, right? I work on gender quotas in Brazil. And when I was reading the article, I was thinking we have reasons to be pessimists. And I was thinking this is a pessimist story. But when I was thinking about Lisa, right? Are we optimists or are we pessimists? I think what you just presented gives us, the narrative art that you're presenting is more of an optimist one, even though you realize that there are, we talk about the backlashes. And I think it will be interesting to hear you more on the backlashes. But I was thinking, obviously, I'm not a comparativist, but I was thinking about the Brazilian constitutional framework, right? And the issue of quotas. And maybe my question is, and because you mentioned, you just mentioned, right, from equal rights to equal representation, so women and minority groups are disputing power now. This is kind of the rule of the game at the moment, to some extent, how these things come together. And I was going back to the Brazilian constitutional framework and thinking, well, it was written under the influence of a small but partially successful lobby of women's movements, right? It became known as the lipstick lobby, o lobby do batom. They helped entrench the equality clause in the Constitution and a lot of provisions regarding women's health, children and adolescents as well, and some provisions against gender violence that came to fruition much, much later. They were themselves an articulation for women's representation in the Constitutional Assembly, so they realized the gender gap at that point. We had only 5.7% of women representatives at that point, and they were like, well, we're not going to get anything passed if we don't act fast. And they had a massive national articulation. It boiled down to 30 points. They presented to these women that were not necessarily feminists, but they managed to successfully co-opt them, and men as well, and passed almost all of the points, except, very importantly, abortion. But they themselves, there was no indication, and I went back to the literature, that political gender quotas were a constitutional claim at that point. And it struck me as odd, at least, or the timeline. And then I was thinking, well, the Constitution grants, on the other hand, political party organizational autonomy, which historically unfolded as Brazilian parties becoming black boxes, right? So with very little public oversight and accountability that hindered women's chances of entering politics. And at the same time, it was like 9 years before Beijing. It was 5 years before the first Argentinian quota. So we already had a discussion about quotas happening. So I was just wondering, first of all, like the centrality of this, the issue of equal representation, or first quotas and then parity, the centrality of this to the functioning of what you are calling transformative gender constitutionalism. So, what is the importance of that in your narrative art, right? And obviously, I was wondering about Brazil. Was it a lost opportunity? Was there lack of awareness, perhaps, or it was just were we a little bit missed the point a little bit by a few years? Mm-hmm. Or was it Brazil exemplary of what was happening at the time? It was a little bit before Beijing, so it was a little bit before this became an issue. And this had massive consequences because, as some of you might know, our gender quotas have not exactly flew. And as with abortion, it feels like the rest of Latin America is moving towards a direction with some countries legalizing abortion, decriminalizing. Brazil is lagging behind. And with quotas, the same thing, right? We had countries that had very much more effective types of quotas and are already now have gender parity provisions, and Brazil is lagging behind. So I was kind of trying to think how we fit into your narrative art, and moreover, what is the centrality of the idea of equal representation, a grab for power, a division of real power, right? Political power and power in other spheres as well. Yeah. Thank you very much.
Perfect. Ruth, would you like to respond to these questions?
Maybe I will start, yes, responding to, so forms or typologies. You're right that other than the exclusionary, the other three forms are not mutually exclusive, although there may be tensions between them. So if you go for a very formalistic understanding of equality, that will be more in tension with substantive anti-subordination notions of equality. So you're right in that. Why didn't I go just for stages? Well, because in many countries you see that the transition to liberal constitutionalism happens much later, and you see these kinds of struggles for equal right or for equal representation or for questioning power dynamics within the private domain, violence against women in the family domain, happening or appearing at the same time. So for them, the idea that these are, phases wouldn't make sense. This is why I play with the two concepts, right? Because depending on when your constitution was drafted, and you're providing us a perfect example, you're going to see different dynamics unfolding. And they may happen at the same time, and sometimes with different logics. Because, of course, one further and deeper reason is, what do you take to be definitional of these forms? Is it the constitutional text? Is it the doctrine? Is it, because the truth is that often you find really interesting cases, but the reasoning of the court is very paternalistic. So these are just tools to help us navigate this, but it's never clean. It's messy as life can be. Now, on gender order, well, I decided very purposefully to use gender because what I do think is that you had a gender order that was foundational of in the liberal constitutional project, which of course affected people, all kinds of gender dissidents. It affected women because it gave them a subordinate position, and it defined for them a form of citizenship contribution, if you may want to call it that way, that was focused on, caregiving and motherhood. But of course, it also affected, all other forms of gender dissidents who were seen as total outlaws, abnormalities, aberrations. And in fact, although, in this book, I can't really do everything, but when I get to the transformative constitutionalism, the one that challenges the family order, I do discuss, there's a big section on same-sex marriage, and there's a big sections on transsexual, transsexuals and the jurisprudence that their litigation is putting to the fore. In some ways, when it comes to those groups, you can see that these advances are simply forms of inclusive constitutionalism. They were never made part of the equal citizenship body, but they're also deeply linked to the transformative understanding of constitutionalism, in which, the family order is challenged at its core, because of course, that's part of the gender backlash. It's not just misogyny. it's the old traditional family that has ascribed roles and where some individuals fit or not in gender and sexual dissidence do not fit, and women fit only in certain roles. So it puts all of them together in this, so I hope they won't be too disappointed. But I did want to put the focus on women's citizenship, because I wanted this to be a book about the interaction between women's claim to citizenship and the constitutional responses on the one hand, but also the attempts of women to define what citizenship is about. And so, you know, is what happens in the family and the care contribution part of citizenship? You know, should we think of cuidadanía and not just ciudadanía, as a colleague of mine discusses? Women judges. In the chapter on participatory constitutionalism, when I mentioned the fact that women are joining as constitutional makers, I mention various capacities. I mention women as constitutional makers, focusing on civil society, right? Because the truth is that we haven't surpassed the 20% threshold in the best case scenarios of women in official constitutional assemblies. But I was humbled, I was telling Roberto this, I was humbled by my experience in Egypt when I went there in the context of the Arab Spring, and I discovered that women were meeting in remote villages, discussing constitutionalism, discussing what they wanted in their constitution. Now this was the whole project was then hijacked, but this happened, and to me this was huge. This was a platform of, you know, grassroots women in their villages and academics who were being accused of being Western sympathizers, so they took it on themselves to study foreign law, but also to recover Egyptian key women in Egyptian history so that they could, you know, create a narrative that was sophisticated. This happened, right? No matter that al-Sisi then had different plans for women and for the whole country. This happened. And so I talk a lot about women in civil society in that, and I do mention the coming of women to constitutional courts, which happens in that participatory moment. In the late 80s and 90s is when you see the first women. Now, unfortunately, you work on this topic, and so you know better than I that for a long time it meant the first woman and the only woman. So it was the woman quota on the bench. And we still have very few examples. Germany is now one. I think there's a few others of parity benches. We still have a heavy underrepresentation of women on the bench. So I think we would need more representation and more time to study the kinds of dynamics and the difference that it makes. Now, of course, you know, I have anecdotal evidence. I had the privilege of interviewing Ruth Bader Ginsburg. The interview is on YouTube. And, you know, I did ask her, and she said, yes, it makes a difference. It doesn't necessarily have to make a difference in the result. It often makes a difference in the reasoning. It's much more contextualized. You know, you can empathize with certain forms of harm that my male colleagues don't see as harms. So often it's not necessarily in the result, it's in the reasoning, it's in the judicial method. But we, I think, would need many more women and much more time to be able to assess. And there have been some really incredible feminist male judges on the bench. You know, Colombia has some, and you know, India has some. So, you know, so it's not just women who will bring about feminist reasonings. And of course, there are issues like abortion on which you cannot necessarily count on a common position because there isn't one. But that's when I locate also the coming to the fore. The other thing that I think is really interesting is women as litigators, because believe it or not, in so many countries, when the first sex equality provisions come into the constitutions, it's men who mostly use them. The litigation is mostly run by men. You know, this was strategically then used in the US, you know, because it was so nice to have a male judiciary and tell them, listen, you know, this man is being discriminated against because of gender stereotypes. But the truth is, Canada, Germany, Spain, first 10 years of case law and gender jurisprudence is male run. And this is because, as we know, the feudal, you know, gender order was one about domination and protection. So the moment you say sex equality and a formal understanding of equality, men go after the privileges, the protections, the special, benefits, so to speak, that women got. So I think that as important as looking to women on the bench is to look at women as litigators, as really, appropriating themselves of a constitution and bringing forward cases to challenge these traditional understandings. Now, I love your example, moving on to your questions of, the gender quotas, because I think that is a perfect example of the line that I draw between old constitutionalism, in which I include European post-Second World War constitutionalism, and newer constitutionalism, which is the one that I describe as taking, place, in the context of Beijing, women's transnational mobilization, CEDAW has been approved. You start having concepts like the bloque de constitucionalidad would receive the input of. And Brazil is indeed kind of in the middle, right? And you're saying it's just, but Beijing was happening. Yes, but look at what was happening too. In Europe, the first gender quotas, I'm thinking of France now, had already been passed. And they had already been struck down by the Conseil Constitutionnel under, what you described, the notion that, we have a unitary political body, general representation is the definition of democracy, right? And political party autonomy. So it's not just that it was too early, it's that it had European reference to look at, right? And in fact, in Latin America, because Argentina, Colombia, and then the rest, and then first it was thresholds, and then, threshold quotas, and then full parity, that political agenda could unfold inspired, covered, protected by these clauses, that were inserted in Latin American constitutionalism. In Europe, I'm thinking of Italy, I'm thinking of France, I'm thinking of Belgium, I'm thinking of Portugal. The constitution had to be amended to allow the participatory claims and the quotas and the parity arguments and claims that were being put forward by women's movements to be reconciled with the constitutional order. It took itself, European constitutionalism took itself, like US constitutionalism does, already to be definitional of liberal democratic standards. This was the difference. Later processes had the possibility and the opportunity to renew those standards. And this is why in new constitutionalism, you find the kinds of provisions you're saying. You find parity, you find violence against women in the Constitution, you find care as a citizenship duty. This is mind-blowing if you look at old constitutionalism. And the idea of the book is not just that these are ever better forms of constitutionalism that gradually facilitate, but that in many ways, old constitutionalism was a stumbling block. It was an obstacle. You had legislation on violence against women, and you had due protection, due process constitutional guarantees limiting those legislations. You had quota proposals, and you had readings of political party autonomy and formal equality limiting that agenda. So in many, you had, I'm thinking of Germany now, attempts to share parental leaves, and you had old doctrines of family neutrality, which in fact had been a coverage for breadwinner family model, limiting those claims. So it's not just ever better, it's that, sure enough, this wasn't the DNA of the constitutional order. Why would you have expected it to be, in many ways, a facilitator? It was a stumbling block. It only became a facilitator to the extent that it has, and here's where I put all the footnotes about law in the books and law in action, the limited reach of constitutionalism and the limited capacity of any constitutional order to be transformative without tackling socioeconomic inequality, the big elephant in the room. But having said that, to the extent that there's promise, it comes much more through these forms of new constitutionalism. So Brazil kind of was there in the middle between these, what was happening in Europe, what hadn't yet happened in Latin America. And it's interesting because it now stands as this anomaly of the one country. So in a way, it seems that these things do eventually have an impact on women's citizenship. Thank you. I don't want to
It's absolutely
You
fascinating.
can feel my passion.
We'd like to now open it up to the audience. If there are any questions, there's a mic that will come around to where you are.
Thank you. No, first I wanted to just use the opportunity to say that your project is fantastic. So to congratulate you is admirable. So thanks for your project, for your book. And then just a common question about the presence of women in institutions of power in decision-making processes. So, for example, you emphasized the importance of having women litigators, but I think it's much more important to, and I'm sure you may share, but to have women in positions for constitutional interpretation. And in that sense, I think it's time to start pushing for parity in the benches, in courts, and just as not as an anecdote, but as a fact that 200 years ago, for example, when the problem of federalism was taken as the main cleavage or a fundamental or crucial cleavage, well, then the Senate was created. And why? Because they wanted to address that problem that was seen as a crucial problem in a nation that was being organized. But in the same way, one should say, well, what are the main cleavages today? And so how to reorganize the structures of power in order to address our, present cleavages. And I think that one crucial cleavage is one of class and the other is of gender. So in that sense, our institutions, I would say, should be rethought in terms of those new cleavages. And so it's totally reasonable to think that in the decision-making legislative procedures, but also in the process of constitutional interpretation, there should be, the organization of power should be rethought in those terms.
Totally agree with you, Roberto. I think that when we look back and we look at the 21st century as this, at least the way it's going now, this democratic catastrophe, the success of the parity movement and the redefinition of parity of democracy to live up to parity claims might be one of the only things that we look back and say this was a huge milestone. Women had suffrage for such a long time, and they were still in the 12% representation in France, la République. Well, it was fraternité, it wasn't sororité, and they meant it literally, right? So, and now France is up the scale. So I totally agree with you, and we don't know what's going to happen with the Chilean constitution. It's the first time that we have a parity in the constitution-making assembly. That is a milestone, a historical milestone. And of course, parity is across the board, all the powers. It should just be definitional. In fact, I would say we need Ruth Bader Ginsburg saying, why not only men? Why not 9 men? Probably we need that to undo the 200 years of constitutionalism that were just done by men, 4 men. So maybe we need, we need a bit of that. But of course, yes. Yeah. Small questions. I'm going to take a few on the time because otherwise I go on and on. Let me take several at once.
I think it's really important and looking forward to reading your book. Yeah, and taking off from some of the things you said, especially maybe looking at the backlash and the ways in which the backlash happens. And, from India, yes, we do have a great bunch of feminist judges, male feminist judges on the Supreme Court who are pushing the gender question. We see that, especially in recent times, the kind of unique ways in which we see a backlash against gender equality claims. And, two big cases in which gender equality was central in India. One was the triple talaq case, where the instantaneous triple divorce in Muslim law was challenged as being unequal for women because it is only the man who can do that. And the challenge, the claim for equal entry into religious shrines for women, where women were prohibited from entering in their menstruating age. In both these challenges, like you said, it's not just the result, but the reasoning as well that's important. While the results were favorable to women, the reasoning was absolutely not. In the triple talaq case, the court outlawed it constitutionally, saying that this was unequal, but it was not on the claim of Article 15.1, which was the claim on women's, non-discrimination on the grounds of sex, which was the central claim by women litigators and women claimants, but the court articulated it on the grounds of arbitrariness and equality, totally divorcing the gender angle to it. And the same thing happened in the Sabrimala case, where the court said that we have to decide this, whether it is an essential form of religious practice and not really as a claim of why were women disallowed from entering. So, I mean, we're also dealing with these kind of unique ways in which the gender question, despite being the central question, is kind of divorced, and other so-called constitutional arguments are kind of given weightage. So it would be interesting to hear your take on that.
Yeah.
Thank you very much. Thank you for the presentation. I look forward very much to reading your book. I think that what you're doing is brilliant and extremely important at this moment. And I have a question about the relationship and arguably the tension between an ethos of rights and an ethos of care. And it's not a philosophical question, and it's not even one that's necessarily legal. But when I wrote Rights at Work long ago, which was a movement about women's rights at work, out of that activism came a whole variety of collectives of women and some with men that were all about care. They were all about, mutual aid and helping each other and trying to reorganize or to reorient towards household relations and so forth. And I remember at one point there was a debate among the women. They said, I thought we were a rights movement. We're really about care. And they asked me, how do you reconcile those? So I've been thinking about this for 40 years to some degree. Yeah. And I'm in the early stages of formulating either some essays or a book about Black Lives Matter in the United States. Black Lives Matter, which in some ways is an inheritor of the long civil rights campaigns in the United States. But the dominant ethos of the contemporary Black Lives Matter is not about rights, it's about care and mutual aid. And that's what I write about, is how do those two live together? Are they a rights movement? Are they a care movement? Yeah. Can those things coexist? Because there's a lot of people who argue that rights and care are are not only separate, but they're actually at odds with each other, largely because rights presume independence, and care is about interdependence, right? So, and I'm interested in trying to write about how I think what's going on is a reconstruction of rights that's more through the ethos of care and interdependence. Patricia Williams, a well-known critical legal studies scholar, made that argument in a book, Alchemy of Rights and Rights, a long time ago, and almost nobody paid attention to it. So I'm trying to say, is Black Lives Matter a manifestation of this new alchemy of rights and care? So let's come back to the central question. How do you think about that, and how can you help us think about this relationship between rights and care?
And that will be the last question, and after Ruth, a comment.
Last question. No one?
That was the last question.
Oh,
that was the last question.
Okay. Yeah. India is a fascinating case because India was actually one of the first post-war constitutions that included a special protection for women and children, right? And there's always the question: was this, in the context of anti-casteism and anti-structural subordination that was the constitution-making moment of India, was this an affirmative action kind of provision, or was this a paternalistic, protectionist type of provision? In the book on Asia and gender constitutionalism, Sharia Trey is writing a chapter, and she's precisely looking at the ways in which the court often comes to the good results but poor reasoning. She actually signals a recent shift with the sodomy laws being struck down, where there's a feminist reasoning, McKinnon is cited and feminist readings of privacy are cited, but she says this is inconsistent. And you're pointing to these two decisions, the menstruating women in the temple and the triple talaq decisions, as examples of how this reasoning can fluctuate. Now, the triple talaq, of course, brings the question of personal status law, And part of what I find interesting is that, in a way, the history of women through constitutionalism is a history of what one could call family exceptionalism. So the idea that the Constitution doesn't apply in the family. And in multicultural context, you have this claim very clearly articulated through religious accommodations and personal status law. But in Western societies, the claim is also accommodated just simply through constitutional doctrine. So it presents that particular edge. And I think about that because I think that the Shabano case and legacy had a lot to do with the court not wanting to go into certain, feminist interpretations of religious law. Question on rights and care. Well, there's the bigger question about, the critical theory and the limits of rights, right? So you know the literature. Having said that, right, so basically there's those who think that rights are a distraction, but you know that literature, and that's one way to go about it. I think there's interesting evolutions that maybe from a US perspective are overseen, but that they are taking place. By the way, Jennifer Nedelsky has a book on relational rights. I would definitely commend you to read that because it's an attempt of a theory of interpretation of rights that looks at the kinds of relationships that rights promote or erode as a basic guideline. But interestingly, the right to care and be taken care of is now in the Chilean constitution that's going to be voted. There's something similar coming in the interpretation of the Spanish Constitutional Court. Ecuador does not only have the right to care, but the recognition of care as a social contribution and the duty, the citizenship duty of care together with military defense, together with paying taxes and being law-abiding. So I would encourage you to see some of these evolutions. I know that part of the literature in the US wants the Equal Rights Amendment that it's hoping will eventually pass to facilitate interdependence and care agendas to get the recognition at constitutional grounds that you're saying. I don't know whether that will ever happen, but I know that at least the literature thinks it might open venues. Julie Suk is one of the people who writes along these lines.
All right, thank you.
No, Mercedes is saying no. We can. I fear I'm going to lose my cup. I hope it's
So to prevent that from happening, I'd like to...
He's going to punish me and not give me my cup. I know.
Okay. Thank you everyone for coming, and to congratulate Ruth on her fantastic book.
Thank you.